Okay, hi everyone. It's 6:30, so we're going to get started. I am Jen Mildren. I am the pro bono coordinator for Legal Aid Service of Collier County. Thank you for joining this webinar. It's being presented in honor of Pro Bono Week. So generally, legal aid would be hosting clinics and in-person presentations this week. And those would be to help local families with a variety of legal issues. But just like everyone else, we've had to adapt to the changing times. So I hope this webinar will reach many of you all over the country, because I think all of this information is very relevant no matter where you live, not just in Collier County or in Florida. So this idea, it wasn't born in a vacuum, because I'm actually a parent of a child with exceptional needs who's now attending in-person school during a pandemic. And it's not easy. So that's why we have put together this webinar. So without further delay, I just want to get to it. Some housekeeping issues first. We plan to take questions during the webinar, but we want you to use the chat option. The chat box is all the way down on the bottom of your screen, whether you're using a phone or a computer. Please type out your question and we will get to them at the end. So we may not stop the presentation for questions, but we will if we find the question to be relevant to what is being presented at that very moment. Otherwise, we'll hold them till the end. Please note that you've all been muted by the host of the meeting. And if you're having technical issues in the use of the chat function, you can contact me or the host, which is Melina. And we've put our email addresses at the bottom of this slide that you see on your screen. You can send us emails, we're monitoring them, and we'll get back to you as soon as possible. So write down these email addresses and use them if you need them, because the slide won't be up for the whole presentation. So let me introduce our panelists. Lisa Goddy is an attorney licensed to practice in Florida, Illinois, and Pennsylvania. She has 16 years of experience. She's currently a partner at Wollman, Gehrke and Associates. She focuses her practice on estate planning, wealth transfer planning, probate and trust administration, elder law, special needs trusts, guardianships, and business succession for business owners. Prior to joining her firm, she worked at a large multi-state law firm and a mid-sized law firm where her practice focused on sophisticated estate planning and complex trust and estate administration. Adria Silva has been named a rising star in employment and labor law by Super Lawyers magazine. She represents clients and students in Title IX or sex discrimination, harassment, and retaliation cases throughout the state of Florida. She's represented many students regarding a variety of Title IX issues, including pregnancy discrimination, access to athletics, harassment, and retaliation against high schools, vocational schools, and universities. She can also represent homeowners and tenants in housing discrimination cases under the Fair Housing Act. She can also represent customers and patrons in cases of discrimination in places of public accommodation, like a hotel or a restaurant. Also students in race discrimination cases, educational employees in disability, gender, race, and religion, as well as retaliation cases. Additionally, she's an expert in 504 plans. Jason Kahn is an educational legal rights staff attorney at Legal Aid Service of Collier County. He provides legal representation to children in Collier County who have learning disabilities or special needs when schools are not providing the services and supports they need to achieve their full potential. Prior to joining Legal Aid Service of Collier County, he worked for the Office of Criminal Conflict and Civil Regional Counsel, where he represented indigent parents in trying to get their children back after being removed due to allegations of abandonment, abuse, and neglect. He's also worked as a best interest attorney for the guardian ad litem program in Fort Lauderdale, where he advocated for the best interests of children in dependency proceedings. Jason's dedicated his whole career to serving underprivileged and underserved clients. He's won the Stetson University College of Law's Pro Bono Award as well. So we have a very, very good panel for you tonight. Lisa's going to start off the presentation with a brief overview of IDEA. Jason's going to then talk to you about an IEP plan, and Adria is going to discuss a 504 plan. And then we're going to move into scenario-based question and answer session. And the scenarios are based on real life questions that I've had and I've seen from parents of kiddos with exceptional needs. So I hope you'll all find these very relevant. And again, please feel free to use the chat option and submit your questions as well. We'll do the best that we can to answer them. At the end of the presentation, there's going to be a slide which gives you the contact information for us at Legal Aid. And if your question didn't get answered here, we'll do our best to point you in the right direction. So thanks again for joining us, and I really hope that you enjoy the presentation.
Thank you, Jen. Again, hi, my name is Lisa Goddy, and I am going to kind of go over an overview of what IDEA is, a federal law, and then kind of take it in, with the different elements of IDEA. What does it cover? Who does it apply to? And then after that, Jason's going to go into a little more depth of what an IEP is, and then Adria will talk about a 504. So I'm going to probably touch a little bit on those, but they're going to go into greater detail on that subject since IDEA relates to those issues as well. So what is IDEA? IDEA, it stands for Individuals with Disabilities Education Act. And it's federal law, so this applies across the board. It's not state specific, this is federal law. And commonly it is referred to as special education law. And I always look at IDEA as a big umbrella, because underneath that, you're gonna have what's an IEP. There's also the FAPE, there's LRE, almost kind of sounds like alphabet soup with all the different letters, but we're going to go through each of those and see what those are about. So first off, what is the purpose of IDEA and why was it enacted? IDEA provides free, appropriate public education to all students with disabilities. Its overall goal is to provide children with disabilities the same opportunities for education as students without disabilities. So different, providing different, oh, there's some slides. Perfect.
Sorry about that.
That's okay. So going back to what the purpose of IDEA, so it provides special education and related services to meet each child's unique needs. Every child is different. Every child has, what works for one child may not work for another child. And so it's very important to kind of look at each individual child's needs. And that is the purpose of IDEA, to cater and tailor educational needs to each child. It is also administered or assists all states and local cities, districts, things like that, to help students make progress in school. So again, you usually are working with your school district, whether that's Collier County, Lee County, or whatever district elsewhere, but you're working with the school district in developing the plan for your child. There are 6 main principles of IDEA, and I'll just kind of cover those. And then we'll take each one individually. The first one is free, appropriate public education. Again, it's FAPE, it's abbreviated there, FAPE. Appropriate evaluation in number 2. Number 3 is individualized education plan, and that's sometimes IEP. You'll see it as an IEP. Number 4 is least restrictive environment, and sometimes you'll see that as LRE, and again, that's usually dealing with placement, and then parent participation, and then finally procedural safeguards. So those are the 6 elements or principles that we're going to cover right now. Number 1, free, appropriate public education. It is important to remember that public education is available for children with disabilities at no cost. That's why we have schools and services for each child based on what they need, what is unique for that child's abilities and disabilities. The second one is appropriate evaluation. Appropriate evaluation is important because every child that is eligible for special education or related services have to go through an evaluation process. If your child has a disability, a parent can request an evaluation. And the disability under IDEA, there's different types of disabilities and different categories, if you will. And it's whether you are eligible or meet that definition, such as autism or a hearing impairment or an intellectual disability. So if the evaluation shows that the child does have a particular disability, then that child is eligible for different educational services, special education, related services. Again, related services can be like speech or OT, PT, or also just accommodations. If we need visual aids or needing to sit in the front of the classroom versus sitting in the back of the classroom or things like that. So again, all these take into consideration the specific needs for each child. Number 3 is the individualized education plan. And again, as I mentioned, Jason's going to take a little deeper dive into an IEP, but generally speaking, in IEP, each state must ensure that an IEP is developed, reviewed, and revised for each child with a disability every single year. It's an annual event, and it's kind of a formal event. And anytime that's going into the school, or in this case, a lot of times they're probably done by Zoom or WebEx or some other type of virtual approach. But the school gets together, and that's typically the special education teacher, a general education teacher, any related service providers, like I said before, speech, OT, things like that. And then a school psychologist if there was an evaluation done, or if there's a behavioral situation. And of course, let's not forget one of the most important people on the team is the parents. And because again, the parent knows what's best for their child. So an IEP sets forth what is the goals and different progress in the education for the child throughout the school years. And again, like I said, Jason will touch a little further on that. One of the things that's really, really important, and is number 4 on the list, and that's the least restrictive environment, LRE. And that is placement. What classroom should my child be placed in? What type of education? General education, special education? How is that setting supposed to look like? And what's very important is what the federal law says. To the maximum extent possible, to kind of summarize, a child with disabilities should learn with other students without disabilities. That is the least restrictive environment. Types of placements, as I indicated earlier, could be in a general education classroom. It could be in a special education class. It can be a special education school. It could be done at home, and that's what we're seeing a lot of right now at this time. Or it can be in any other type of public or private institution. But I always say, remember, each child's needs are unique. Every child is different, and what's important to one is different for someone else. So placement that is least restrictive to one child may be different for another child. 5 is parent participation. Parent is involved in the IEP process. Parents have a say in the decisions that the school makes about the child's education. And that's obvious because the parent knows the child best. And what better way to know what the child needs and to work with the schools as a team is to have that camaraderie between the school and the parents. And finally, procedural safeguards. Again, IDEA sets forth different rights, protections, and as procedural safeguards that a parent has. And so I use the example, the school must give parents or get the parents' consent before providing services to the child. And a lot of times in an IEP situation, school will hand out those procedural safeguards and the rights that they have at that time as well. So now what I'm going to turn it over to Jason to kind of dive a little deeper into the IEP world.
Hi, my name is Jason Khan. I will be briefly talking about IEPs. An IEP stands for Individualized Education Program. It is a legal document developed for each public school child in the United States who needs special education. It can also include charter school children as well, as charter schools receive federal funding. IEPs are developed by the IEP team, which consists of parents, teachers, school district personnel, psychologists, attorneys, advocates, or any other person that the parent wants to bring to the meeting that they believe can contribute to the meeting. IEPs must be reviewed annually to keep track of the child's educational progress. Reevaluations must be done every 3 years to gather new data to decide if additional testing needs to be done. Types of testing includes academic testing, achievement testing, occupational therapy testing, speech and language, etc. The type of testing will be dictated by the nature of the child's disability. The IEP outlines the services for all eligible students with a disability. Eligibility. Any child in the United States between the ages of 3 to 22 attending a school that receives federal funding that has been evaluated as having a disability that interferes with their ability to learn such that they need specialized instruction. And there's a list of 13 qualifying disabilities, which include autism, specific learning disability, or other health impairment. Proper psychoeducational testing must be done with parental consent. And once the parent signs the consent, the school has 60 school days to complete the evaluation. Next, I'll be talking about the elements of an IEP. IEPs are data-driven, which means they include a lot of data about the student. They include the student's present levels of academic and functional performance. Most of this comes from the psychoeducational testing that includes IQ, achievement scores, etc., occupational therapy scores if applicable. IEPs measure students' annual goals, including academic and functional goals. Goals may include reading, writing, math, social, emotional, or independent functioning. The IEP shows the progress the child is making towards meeting those goals. An IEP also includes special education and related services, program modifications or supports, least restrictive environment data, explanation of any time the student will not participate with their non-disabled peers, a transition plan. A transition plan is typically for students who are 14 or older, and the plan helps prepare them for post-secondary education or adult living. IEPs also include any other pertinent information. Procedural safeguards. Procedural safeguards are procedures in special education explained to a parent or guardian in order for them to be informed throughout the special education process. They are usually mailed to the parent ahead of time and presented again to the parent during the IEP meeting. Common procedural safeguards include parent participation in the IEP process, prior written notice in the parent's native language, and the right for the parent to submit a due process complaint if they do not agree with the IEP team's decision. I will now turn it over to Adria Silva to present 504.
Hi, everybody. I'm Adria Silva, and I'm going to talk to you today about 504 of the Rehabilitation Act of 1973. And essentially, 504 prohibits discrimination in any federally funded program, including schools, mainly public schools. The first thing I would tell you is know the rules. Each school district, each college, each university has information published, usually in the student handbook, regarding who may qualify for a particular service, how to request one, and what to do if things don't go quite your way. Now, since we are in a time of pandemic, the other thing I think is important before we get into the details of 504 is understanding COVID. Most federal government agencies, like the Centers for Disease Control, the CDC, recognize that COVID is a direct threat to the health and safety of the general population. And what this means in terms of services for your child is that you may have teachers and staff and aides that don't necessarily want to come back to in-person teaching because of this threat to their health and safety or those in their household. That's an issue. Another issue can be is if your child is at severe risk for severe COVID. Again, the Centers for Disease Control, the CDC, has a list of certain conditions that rise to that level. I think in the most current guidance, it states diseases such as sickle cell disease or other anemias or hemoglobin disorders qualify as severe risk. Diabetes is another condition that is identified as a severe risk of COVID. Other conditions, the jury is still out according to the CDC. They are still determining whether or not there's enough data to show that there's severe risk, and that may include something like asthma. But what that does is if you want to keep your child at home and virtually learning or back in school with some accommodations, you may be entitled to additional accommodations because of the child's severe risk for COVID. What is 504 and how is it different from IDEA? Well, generally 504 says that a child with a disability is going to stay in the general classroom setting with or without a reasonable accommodation. It gets a little confusing because there is some crossover, because an accommodation under 504 can include supplementary services or special education or related services. However, when we talk about a disability, it's not a disability and there's no definitive list of disability, and it's not what we think of every day when we're walking down the street. Disability under 504 is defined that a condition, any condition, that substantially limits one or more major life activities can qualify your child for an accommodation. And such things that are considered major life activities can include walking, talking, thinking, reading, breathing, eating, and even reproduction. This is not the end-all be-all list. This is not an exhaustive list. This is just an idea of the major life functions that can be affected and qualify your child for a disability accommodation under 504. You're going to have to provide medical documentation and or an assessment to get that accommodation. A simple diagnosis is not going to be enough. What ideally you want is something in the assessment that shows what the condition is, how it affects your child's life, how it affects that major life activity, and what types of accommodation the medical professionals feel might best suit the child in the educational setting. Again, like IDEA, the school has to be a federal funding recipient. They have to get money from Washington, D.C., the federal government. And most public, if not every public school district, qualifies. There is some talk about charter schools. And if the charter school is sponsored by another entity, it can be a private entity like a private company, or it can be a public entity like a school district or a public community college or a public university. And if that private sponsor is getting federal funding, they have to comply with 504. And if the sponsor is a public school district or a public community college or a public university, which do receive federal funding, then that charter school has to provide accommodations as well. What I see across my desk is that there's sometimes a disconnect between the charter school and their sponsor. And oftentimes going back to knowing the rules, that charter school will not have in their student handbook a referral back to the sponsor if things are not going quite the way they should under 504. If that happens, what I would suggest is that you talk to somebody outside of the school system, perhaps a lawyer, to see what your options are and how you can get things resolved in the most efficient and quick manner for your child. Unfortunately, private schools, at least at the K through 12 level, are another matter. Some receive federal funding, some don't, most don't. And so that private school that does not receive federal funding may not have to comply with 504. However, when you get past the primary and secondary level, past K through 12, when you are at the college or university or vocational or technical school level, most of those entities or institutions receive federal funding in terms of loans or grants. And so that makes them have to comply with 504. How do you get a 504 accommodation for your child? Well, the school may identify your child as having a potentially qualifying condition, and they may be testing or assessing the child. On the other hand, you may have to ask. That's the first step. Ask. All the school district can say is no. They're going to set up a meeting with you, very similar to IDEA. However, have your medical assessments ready. If you do not come into that 504 meeting without your medical assessments, it's going to delay the process and delay services to your child, because the school will wait until they get the assessment before they implement any accommodations. What happens next is that you engage in what's called the interactive process. You as the parent and the child and representatives from the school district, including the 504 coordinator, will talk about what accommodations will best fit your child and their condition. Remember, under 504, and it's different from IDEA, is that you only get a reasonable accommodation. And that accommodation may not be the one that you like the best. And certainly when I'm with my post-secondary students at the college level, I have seen colleges deny 504 requests for accommodations because they are unduly burdensome or a financial burden, financial hardship. So that's something else to consider. Even before the pandemic, I was saying, put contingencies in your plan. Remember, I said under 504, we want the student to be in the general classroom setting, and that can be either with an accommodation or without an accommodation. Now, a student may have a condition and they may be assessed as perhaps not needing an everyday accommodation like extra time on tests or note taking. But when I talk about contingencies, it's a good idea because that's what an enforcing agency or an attorney is going to look at, the four corners of that agreement. And sometimes, especially if a child's like on medication, for example, the medication may stop working, it may not be as effective. And if the child has coextensive conditions, one or more disabilities, and is taking medication for all of those conditions, the medications may have interactions that affect learning abilities and or behavior. So you want something in that 504 plan to fall back on. During the times of pandemic, it's especially important because we are in a virtual learning setting. And although some school districts are going back in person or using a hybrid method, there is a possibility, especially with the surge of cases going on right now, that schools could be forced to shut down again. So it's good to have that contingency plan in there. Contact your 504 coordinator. It doesn't have to be, they may not get to you right away, but it certainly should be relatively quickly. You don't have to wait for the end of the semester. You don't have to wait for the end of the year. If a school refuses to talk to you or engage in any kind of interactive process with you, at that point, you may want to talk to an attorney or somebody outside of the school system. But getting that 504 plan is only half the battle. A lot of times the 504 plan has to be revised. In practice, a student may see that certain things on the 504 plan are working in the classroom and maybe other things are not. For example, and my daughter gave me permission to say this, she has ADHD and she has a 504 plan at her university. And she was telling me that she wants to ask for additional accommodations that she thinks will help her in the next semesters to come. So again, if something's not working or you think you might need additional accommodations, you may have to go back and renegotiate or tweak that 504 plan. Another issue that arises is some kind of a disconnect between the written plan and how it's implemented in the classroom, especially like with note taking for some reason. A lot of teachers do not want to share their notes, so note taking accommodations can be accomplished. It's like a proprietary thing. It's their work product. They don't want to share. And so this often becomes an issue, how to get the teacher or the professor to comply with the 504 plan. And you may have to go back to that 504 coordinator to get them to get that teacher or that professor to comply with the plan. One thing I've seen post-pandemic or during the pandemic is that a lot of lessons, a lot of notes, a lot of PowerPoints are now online for the students to view. So this is actually helping some students, especially those that need note-taking accommodations. Another thing to remember about 504, retaliation is prohibited. You can't take an adverse action against the parent or the child because they request an accommodation, they engage in the interactive process, they want to tweak that accommodation, they want to ask for different accommodations, can't retaliate against them. Also, 504 is a lot broader than IDEA. It doesn't just deal with plans. If your child is being segregated in the classroom because of their disability, that could be disability discrimination under 504. Moreover, if your child is getting harassed at school, that also could be disability discrimination under 504. Okay, let's see if this sucker is going to move. There we go. A related issue. I just wanted to bring this up as well because I did see this during the pandemic, and I did see things like this coming across my desk. So standardized tests are not regulated through the school district, although the school district will provide information to these third-party providers like College Board about what potential accommodation the student may need. And some standardized tests are the ACT, the SAT, maybe an AP exam, an advanced placement exam. And something that we saw is that shortened tests during the pandemic because everything went virtual. And a couple of cases that came across my desk dealt with accommodations. In school, the accommodation may have been twice as long for the student to take the test, but maybe the third-party testing organization was only providing an hour and a half, time and a half extra. Again, it's a reasonable accommodation. Again, know the rules because these third-party testing services also have internal appeals you can use before the exam. Just something to note. And if there is an issue, you know, when you do apply to colleges, when a student does apply to college, they can always explain it away. There's usually a section in that application to say, is there anything else that we should know? Finally, if there is an issue, you can do a number of things. You can contact a lawyer. There are lawyers that, you know, deal with breaches of 504 plan and other kinds of disability discrimination in the school district. You don't need a lawyer. You can also file a complaint with the U.S. Department of Education Office for Civil Rights. And I've listed the address and the email and the fax or the good old fashioned telephone number if anybody wants to complain in that route. If you do have an issue with a testing service, and I did not put this in the slides, you complain to the U.S. Department of Justice, Civil Rights Division, Disability Rights section. And that is the end of my presentation. Thank you.
Yes. All right.
Can you see my screen?
Can you, here. All right. So now this is the fun part because now we're going to turn into looking at examples and scenarios and kind of see how all these rules and laws that we've just talked about, and let's apply them in our situation. And so let's start with scenario number 1. This is an example of in-person learning. And we have Jake, our second grader at elementary school. Jake has been on an IEP since pre-kindergarten. And since kindergarten, he has been fully included in general education curriculum, with the exception of 2 hours per day for pullouts for required services. However, after the during the pandemic, but coming back to school in August, he was unable to attend his general education class. And he was only allowed to participate in person learning in a small group setting with his peers, also on IEP. So let's take a look at what from an IEP standpoint, we'll start with Jason first.
So I would make the argument in this scenario that Jake has been denied a free and appropriate education in the least restrictive environment. FAPE, as we talked about earlier, is an individualized education program that is designed to meet the child's unique needs and from which the child receives educational benefit and prepares them for further education, employment, and independent living. FAPE is an educational entitlement of all students in the United States guaranteed by the Rehabilitation Act of 1973 and IDEA. Least restrictive environment means that Jake should spend as much time as possible with his non-disabled peers. Students with disabilities have a right to be included in both academic and extracurricular programs of general education. Another argument I would make is that the district is in non-compliance with the IEP. After an IEP is developed and placement is determined, the teachers are responsible for implementing all educational services, program modifications, or supports as indicated by the IEP. Parents have a right to request a meeting at any time. IEPs expire after 1 year. IEPs are changed and updated annually, but can be done so earlier if a member of the IEP team feels that a meeting needs to be done. Jake's parents need to request a meeting to address concerns with Jake not being in general ed. Even if Jake were a virtual student, he should be with his gen ed peers at least part of the time as specified in the IEP. Now I will turn it over to Adria for her 504 analysis.
Okay, so if this isn't in the 504 plan, then we remember we cannot segregate students. If this is not in their 504 plan, we cannot segregate students from or take them out or affect their educational opportunities under 504. The other thing is, and I just want to mention this, in very, very limited scenarios, if the student is blind or visually impaired, you can't take them out of general education or have them not participate in general education, because that's a violation of another law called Title IX of the Education Amendments of 1972. And generally people think, well, Title IX is the gender discrimination law, which is true, but it also includes a provision for blind and visually impaired students. Thank you.
All right, so let's look at scenario number 2. Similar to scenario number 1, we're going to look at another least restrictive environment situation. And we have another elementary student, Amber, that is in 1st grade. She is doing hybrid learning. And so she is in school for 2 days a week and then virtual for the remaining days of the week. So, so now we're in a hybrid situation. The district determined that a hybrid would work the best. And now that she is back in school, she has certain exceptional needs and is in a general education curriculum. But when she returned back to school for the 2 days a week, she was told that she is no longer able to actually attend general education classroom. But instead, she was placed in a special education classroom where she is with her peers in the classroom via WebEx. So again, let's get the perspective from both on IEP side and also from a 504, but we'll start with Jason on the IEP side.
So again, in this scenario, I would make the argument that there has been a denial of FAPE in the least restrictive environment. Amber should be entitled to return with her peers. It may be more appropriate for Amber to be in the classroom with the rest of her peers and attend special ed virtually. Removal from the general education class should only happen in rare circumstances. District non-compliance also seems apparent in this scenario. Amber's parents should request an IEP team meeting to discuss their concerns. Some virtual instruction is okay, but there should be a mixture of both to ensure that FAPE in the least restrictive environment is met. Additionally, the school district cannot make changes without parental consent. Psychoeducational testing should have been done once every 3 years, and the IEP should have been reviewed annually with parental involvement. So proper implementation is important. Why is Amber now with only special ed students when this was not the case before? So in this scenario, Amber's parents definitely need to request a meeting. I'll now turn it back over to Adria for her 504 analysis.
Well, again, 504 is different than IEP. The idea of 504 is to keep the child in the general education setting. And if there is nothing in the four corners of that 504 plan that talks about being separated into general education for the in-person days, then that's a 504 violation, not only of the plan, but potentially underlying discrimination issues as well by segregating the student out of general classroom setting.
All right, so let's look at scenario number 3. Now we're going to turn into look at middle school, and we have a 7th grader, Amy, and she attends ABC Middle School. The school district and the students in the district are attending full-time in-person learning with extra precautions, masks, and things like that. Amy is a special needs student, again in the 7th grade. The school district advised Amy's parents that they don't want special needs students to risk extra exposure. And they are telling them that they cannot come in and eat lunch in the cafeteria. They cannot participate in gym class, or they cannot attend any other classes outside of the regular general classroom. So again, let's look at from an IEP perspective, and then of course a 504 perspective, starting with Jason.
Again, in this scenario, I would argue that there has been a denial of FAPE in the least restrictive environment, as well as IEP non-compliance. Amy's parents should request a meeting to go over IEP non-compliance. The district must follow the IEP. They cannot change it without input from the parents. There needs to be other implementation done by the school, maybe better protective gear or masks, because least restrictive environment requirement must be met. Amy must be able to interact with her non-disabled peers in order for FAPE to be met. Also, another main key theme of IEPs are they're tailor-made. They are handled on a case-by-case basis. So the IEP team should meet and come up with a way in which Amy can get time with her non-disabled peers. Seems like in this case, the district is trying to have all of the disabled kids to come in one way rather than handle them on a case-by-case basis. I'll now turn it over to Adria for 504 analysis.
Now, if this request to be separated from lunchtime and PE and interaction came from the parents of a child with a condition that made them more susceptible to severe COVID infection, that could be an extra accommodation that we talked about that might be required under 504. However, if it's a child who's back in school and the parents haven't requested that, and if they have a condition that makes them more susceptible, the school district can talk to the parents, but they can't make any changes or segregate the child from the general school activities or the general classroom setting without the parents' consent. Just separating somebody who's not at severe risk of COVID could be considered discrimination under 504. And one other thing I want to make a point of is that 504 does not just encompass the plan, the accommodation plan. It also encompasses other forms of discrimination against a disabled student.
All right, thank you both. Now we're going to turn to scenario number 4. 504. And this one is virtual learning only. So we've covered kind of in person, we've covered a hybrid situation, and now we're looking at a situation where it's virtual learning. And Brandon is attending school virtually. And Brandon's parents have requested an in-person para for additional support, but the district refused. Instead, the district implemented a contingent learning plan without consulting the parents first. Now, what do? Let's start with Jason.
So contingent learning plans are a district's unilaterally offer of FAPE during an emergency situation such as COVID. They differ from state to state. A district is not required to conduct an IEP meeting or issue prior written notice. Contingent learning plan is intended to document the district's good faith effort of FAPE in light of the pandemic. They are developed in accordance with the IEP and on an individualized basis and does not require parental agreement or consent. However, the schedule for the implementation should be developed with the parent. The district, however, still has an obligation to provide FAPE and due process despite COVID. If Brandon's parents request a meeting, they still have the right to have that meeting, even if it's held virtually. Brandon has to be able to access the curriculum in order for FAPE to be met. Perhaps, depending on what Brandon's disability is, he may not be able to access the curriculum without a one-on-one. So although he may be entitled to that para perhaps after the pandemic, but school districts should do everything in their power to provide him with as much virtual one-on-one support, even if it's done virtually, so that he is able to access the curriculum. I will now turn it over to Adria for her 504 analysis.
I can't remember if I was going to give a 504 analysis on this because a para is not probably anything you would see in a 504 plan, although it could be. But again, we did talk about contingency learning plans, and if one is implemented, you have to engage in the interactive process to see if it would be viable or not. But I don't know if that would actually come up in a 504 plan. It could, though.
Okay, thank you both. All right, let's look at scenario number 5. And this one is, we're going to take it a different direction. We're going to look at a behavioral plan. And we have, again, a virtual learner, a 5th grader, Tom, and he has a behavioral plan in place. His parents have requested assistance in implementing the plan virtually, as Tom is no longer receiving in-person services. Tom's parents are wondering what is required of the school district and how these plans can be implemented virtually. So I'll turn this over to Jason from an IEP perspective. What are your thoughts, Jason?
So a behavioral intervention plan may need to be developed, reviewed, or revised as needed to support Tom's behavior and does not require an IEP meeting unless specified in the IEP. Behavioral plans are usually meant to address school settings, but when new behaviors emerge, part of what a district can do is provide counseling to the parents for whatever issues they may see at home. This can include a behavioralist coming to the home, which may not occur because of COVID, but that's something that they are entitled to in normal times. And the behavioral plan may need to be revised when school resumes. I'll now turn it over to Adria.
Yeah, again, it's a tricky area because I'm not sure a behavioral plan would actually be an accommodation under 504, although it could be, because again, it goes back and forth. But what I would say is that, because I have seen some 504 plans where they talk about behavioral issues and not implementing discipline until those behavioral issues are discussed. So I don't really feel that I can answer that question beyond that.
All right, so let's look at scenario number 6. And this one is looking at a transition situation from virtual to in-person learning. So right now, we have students that are attending the school district and are learning virtually. However, they have decided that they are going to transition back to in-person learning on November 2nd. And we have Alice and Bob's parents are worried about the sudden transition as their children struggle through this sudden change. They had inquired with the school and requested a plan to ease the transition, but the school has declined to provide them with a meeting or a plan to help the students adapt. They are expected to be at school in person on November 2nd, and the parents are worried. So let's start with Jason on this question. What are your thoughts?
In this scenario, I would argue a violation of procedural safeguards. Parents are entitled to a meeting in a reasonable time per their request. If some students need a transition for FAPE to occur, then the school district needs to accommodate this. IEPs are supposed to be tailor-made. There is no one-size-fits-all approach. For example, a student with autism may have a tough time going from being at home all the time to then going back to school all the time. So I would make the argument that the district needs to make this transition occur. I'll now turn it over to Adria.
Again, under 504, the questions I would ask are, what is the child's condition? What does that medical assessment state? What are in the 4 corners of that, that 504 plan? Because again, the child's only entitled to a reasonable accommodation, not the one they like best. And if the school district refuses to engage in the interactive process in this type of a scenario, it may or may not be a violation of 504, and you certainly would want to talk to somebody outside of the school to see if it is, perhaps like a lawyer or perhaps somebody at the Department of Education.
All right, so let's look at scenario number 7. And this one's regarding compensatory time. And Jason, I will ask you this question. So we have a situation where Claire has been participating in distance learning since March, and Claire's IEP shows that she has not regressed in any of her goals since the pandemic. However, the IEP clearly shows that she has not made any progress. Claire's parents have requested compensatory time to get Claire back up to progressing in her goals. However, the school informed Claire's parents that regression, not progression, is the metric for determining whether or not compensatory time will be awarded, and she is therefore whether she's entitled to such compensatory time. So what are your thoughts on this issue?
I would make the argument that the school district is incorrect, as compensatory time can be decided using any type of data as the courts have broad authority under the idea to grant any such relief as it believes is appropriate. So Claire's parents should request a team meeting and have the IEP team show whatever data they can. This should include IEP goals, progress reports, and if needed, parents can request new testing to see how her scores are compared to how they were pre-pandemic. The purpose of Comp Ed is to remedy the district's failure to provide FAPE in the first place. So I would make the argument that she can get compensatory time. It just depends on what data the district can show. And also in this area, because we still have an ongoing pandemic, there's still practitioners in this area are still curious to see how courts will actually award this once the pandemic is over. I'll now turn it back to Adria for her analysis.
Well, I'm not going to give an analysis because that's not really
right. There is no
compensatory time,
504.
and regression is not really something that comes up in 504. So.
All right, so our last scenario number 8, is a situation where we have, again, a virtual student. And Bobby has been attending elementary school or in school virtually, but Bobby's parents don't have a lot of money and they have no internet, nor the means to purchase him an adaptive device. Bobby's school district will provide him a laptop, but unfortunately he's not able to use it since he doesn't have internet access. Bobby is now falling behind. What should Bobby's parents ask for to assist him in his learning? And let's get both perspectives on this one. So we'll start with Jason.
So I would make the argument in this scenario that there has been a denial of FAPE because Bobby's having trouble accessing the curriculum. In order for FAPE to be met, Bobby has to be able to access the curriculum. And this needs to be done at public expense. So it's not sufficient that the district just provide the internet or just the laptop. They also need to provide the internet and the adaptive device. Additionally, if Bobby or Bobby's parents don't know how to use the laptop, it's their obligation to provide the training so that this can occur. Additionally, Bobby cannot be forced back to school in person if the family does not want this to occur due to COVID. I'll now turn it back to Adria.
Unfortunately, I cannot give a definitive answer, but what I can say is, again, under 504, the accommodation has to be reasonable so that Bobby can keep up with the general classroom setting. Again, at least at the post K through 12 level, I have seen funding recipients or colleges or universities deny accommodations that are undue burdens and financial hardships. So that would be the question. Would providing internet access be an undue burden or financial hardship? A couple other ideas. There are some public interest groups that are providing internet connections and access to internet, and that may be another route for Bobby's parents. Another thing is that if Bobby lives in a predominant area of historically underrepresented people, there could be a violation of Title VI of the Civil Rights Act, which prohibits race or national origin discrimination in federally funded programs, including schools. The last thing I want to say as we're concluding is that, again, it depends on the type of plan your child has. IDEA is different than 504. There are different requirements, although sometimes things can overlap. Finally, there may be different enforcement requirements under 504 and under IDEA. And all of that should be explained to you in your various meetings with school officials. And if not, please go to an attorney who can explain what you may have to do to enforce a plan and what your rights and remedies may be under the various plans. Thank you.
Okay, if anybody has any particular questions, I will give you a couple minutes to type them in the chat box, but otherwise, that concludes our presentation for tonight. And I really hope that you have found it to be beneficial, and just know that legal aid is here for you if you need help. And tomorrow night we are presenting a webinar called Know Your Rights as an Employee during a pandemic, and this will be a question and answer session. So any questions you have, we have a wonderful pro bono attorney who is willing to help answer those questions for you. So if there are no questions, there is legal aid's phone number and address, and you have my email address from the beginning of the presentation. I would also really love to thank Jason, Adria, and Lisa Again, Jason works for legal aid, but Adria and Lisa just did this out of the kindness of their hearts, because that is why we celebrate pro bono in Collier County. So thank you for joining us, and I hope everyone has a great evening. And you can also watch the recorded version of this if you need to refer back to anything. We'll be streaming it on our legal aid website and various other places. So have a great night, everyone.
Thank you.
Thank you.